Good morning and welcome to the Constitutional Review Commission Online Media Diaspora Engagement, an opportunity that will offer the diaspora to also contribute towards the draft constitution. Today with me here is Justice Cherno Sulayman Jallow, the chairperson of the Constitutional Review Commission, QC. Justice Jallow will be here to take question from Gambians who are not fortunate to attend our public consultation on our final phase of the draft constitution. We will endeavor to take as many questions as possible because we believe the diaspora is also a very key stakeholder in this entire review process. My job here is going to be very simple. I will moderate and then take your questions, and Justice Jallow will endeavor to answer your questions. Justice Jallow, this is our first diaspora engagement. Many people are looking forward to the final phase where we will also go to the diaspora. Now they said they don't think that is possible. So this is another opportunity for them to also participate in this review process. Your opening statement, sir.
Thank you very much, Seni, for first of all for making this arrangement to enable our compatriots, like you rightly said, who are unable to be here with us, to participate face to face in the final phase of the constitutional review process, to participate, online. It is certainly a pleasure. I mean, it's been a long journey, and we are glad that we are nearing the end, and we've seen a lot of goodwill participation from Gambians right across the board. Obviously, the draft constitution, since its publication, has evoked a lot of responses, a lot of reactions, which is exactly what we were looking forward to, because as I indicated when we started this constitutional review process, this is a national endeavor, it's a national exercise, and everybody has to have some level of engagement in the process, and that is precisely what has assisted us to prepare the first draft of the constitution, and we've now rolled it out, and we are seeing people reacting to it, and that's a good thing. And what we hope is that at the end of the day, all ideas conversed, we'll be in a better position to finalize the draft constitution. Yeah. But let me add one more thing. I mean, you did indicate that we couldn't go to the diaspora. Yes, certainly we couldn't, because that wasn't really part of our action plan from inception. But we did indicate that we would visit the diaspora, and we did. And we thought it was an effort well undertaken, and we're really pleased that we did not only undertake that that engagement, but the people in that diaspora who actually turned up to our meetings have actually given us a lot of good ideas.
And that is for the first time those tasked with drafting a new constitution went extra mile to include the diaspora in this review process. Why is the CRC involving the diaspora in this review process?
Our people in the diaspora are Gambians. They have a stake in the design and development of their own constitution, irrespective of where they are in this world. Once you're a Gambian, you're a Gambian. The opportunity afforded to Gambians whom is the same opportunity we felt should be afforded to Gambians outside of the Gambia. We are in a world where people move around for different reasons, and that alone should never, in my view, be a good reason for exclude them in a national endeavor of this nature.
Thank you, Justice Jallow. For those viewing, this is the Constitutional Review Commission online engagement with the diaspora Gambians who are not lucky to be part of this final phase of public consultation. As I said, we're going to invite questions from anyone who is interested in the review process as per the draft constitution. So, Justice Jallow, before questions start flowing, I would just like to ask you, what is new in this draft constitution? Because there have been a lot of questions that the 1997 constitution that the CRC is reviewing and analyzing, there are new provisions. So tell us what is new in this draft constitution.
Thank you, Sini. Before I do that, perhaps it's important that I outline the whole purpose of a review, whether it's of a constitution, of a statute, or some other law. And the essence of it is really to look at the existing, in this context, the existing constitution, to determine what in the constitution is good for us to retain, what in the constitution is not good enough, that we probably need to take out, what in the constitution probably we just need to improve upon, and in addition, what is there that we consider so fundamental that we need to include it in the constitution. So the 1997 constitution, I will never argue that it was entirely bad, because it wasn't. I mean, the fact of the matter is, it has been tampered with, since the original CRC presented their draft constitution and their report, and I think that's where the problems have arisen, with so many amendments being effected, to the extent that nobody was really sure how many times the constitution had been amended. So in essence, that is what I think people need to understand. It's not everything in the 1997 constitution that we have done away with. But in terms of the new elements, there are quite a number of new elements, and that has been brought about as a result of the views and the opinions we have been able to converse from Gambians both at home and abroad. And people have said to us so many things. Obviously, not everything could and did make it into the constitution, and but there are new elements. For example, the issue of governance was central in every place that we have been to, including the diaspora, that we need strong institutions. They need to see accountability in government. They need to ensure that ultimately the holders of office are properly protected, so they can discharge their responsibilities in a meaningful and progressive manner. So we've created new chapters, which may be viewed as unique in some instances, but not necessarily so unique, particularly in the context of a people-centered constitution. So if you look at, for instance, in the draft constitution, we have a whole new chapter on leadership and integrity, because people emphasize this. People said to us, we want leaders who have good character. We want leaders who will be there for us. We want leaders who actually have the public interest in mind. It is difficult, obviously, to legislate for everything, but there are certain fundamental principles that we needed to outline. And you'll find that in most chapters, particularly in the key chapters of the executive, the judiciary, and the legislature, we have outlined certain guiding principles that everyone must abide by. And on the leadership and integrity, we've also outlined adequate provisions, in our view, that will effectively guide the office holders, and for them to realize that as leaders, and this is, I'm not talking only about the president or members of the National Assembly, every office holder has a responsibility to the state, has a responsibility to the electorate, to the citizens of this country, and all of them are governed by those guiding principles that we have outlined. But we have even gone beyond, based again on what the people have said to us, that those persons who are not in government, but for some reason have a relationship with government, whether in the form of developing contracts, or other mechanisms, they also have responsibilities to the state. For example, to be honest, to deal with government fairly, because government deals with public resources, and things like that. So all of those elements are factored into this new constitution. We've also enhanced the chapter on sovereignty, where we've made it practically people-centered. We've developed a people-centered constitution, whereby we made it very clear that those who hold that power as a form of delegated authority from the people, and that responsibility is there. It applies to the government, it applies to all the organs of government actually, and it also applies to local government authorities. So that is fundamental. We've also created a new chapter on independent institutions and offices. There are 6 of those offices and institutions. These are considered fundamental to every governance structure within government. And that is the reason for developing those. The IEC, for instance, the Office of Auditor General, Central Bank, National Human Rights Commission, Anti-Corruption Commission. These are all considered fundamental institutions to good governance in any democracy. So we've created a full chapter on that, whereby we assure integrity to these offices, non-interference, and also accountability in terms of how they carry out their responsibilities. Another new chapter is on land, environment, and natural resources. And Gambians have actually been saying a lot to us on these particular subject matters, particularly those at home, that they need to see the land ownership issues addressed, particularly to ensure that land owned and land ownership issues in relation to locals is actually something that is properly protected. And we've provided mechanisms for that. Not everybody may necessarily agree with that. But obviously, when people spoke to it, they are looking not only to the present generation, they are looking more to the future generations. They're thinking more about how do they protect land so that their grandchildren, and their children, and so on, and generations yet unborn can actually come into this world and into this country, and have land available, become beneficiaries of that. So if we dispense with everything that we have currently, that's poor planning. And these are things people have said to us. We haven't made up anything in this particular regard. So there are all of these new elements. But in other existing provisions, there are also new provisions that we have been able to provide in this draft constitution. If you want to go through all of them one by one, I'm sure this meeting, this dialogue here, I will not accommodate that.
Yeah. Thank you very much, Justice Jallow, for brilliantly explaining some of these key new provisions in the draft constitution. I know my technicians are on to see if we have our first question that the diaspora is sending in. But without that, we will keep the conversation going, and then we'll talk about a whole lot of issues. Mr. Chairman, we visited the diaspora, and we had very fruitful conversations with them. What are some of the areas in the draft constitution that capture the issue of the diaspora?
Well, if you look at the constitution, you will never find the word diaspora in it. And I think this is one area where some people have had the misconception that the constitution doesn't cater for people in the diaspora, which is actually not the case. What we have done, if you look, for example, at chapter 6 of the draft constitution, which deals with citizenship, we have tried to remove this distinction about Gambians being Gambians by birth or Gambians by descent. Once you're a Gambian, irrespective of where you are born, and once you are born of at least one Gambian parent, then you are a Gambian. That distinction we have removed, and that's one of the areas where people in the diaspora have actually expressed concern about. So we have addressed that. So what we have provided for in the draft constitution is to ensure that we do not create any distinction whatsoever between citizens. And in that particular regard, if you look, for instance, one of the areas that the diaspora has advocated very strongly is to provide them with the opportunity, the ability to participate in elections that are conducted in this country. Mm-hmm. And provision is made there that all Gambians have a right to apply to be registered to vote, and every Gambian has a right to vote. This is made very clear, irrespective of where you are stationed in this world. It is a question of how the logistics are carried out, and that is a matter we leave to the electoral body to deal with.
Yeah, because this is a conversation that has been going on online with regard to the diaspora. They said, look, we have not seen anywhere in the constitution that say diaspora. And they say, why are we consulting them if we did not make mention of them in the constitution to vote and to be voted? But I think that position is very clear now. Chairman, we are receiving a lot of questions online. So there is a question coming from one Sambu Dabo. He said I should ask you why. He said, ask him if this is the new constitution, and that is if any MP have been expelled, whether he or she will go for a by-election. What he's trying to say is, what is the guideline with regard to MPs being expelled from their parties in the draft constitution?
What we have provided for in the draft constitution is that if you are elected on a party ticket and you become a member of the National Assembly, subsequently the party expels you from the party, you do not lose your seat. You know, you do not lose yourself because it was the party that expelled you. But you can only function in the National Assembly as an independent candidate. You cannot join another party. All right? We made that very clear. Similarly, if you are an independent candidate and you choose to join another party, then you lose your seat. You know, you cannot, because people elected you in a particular platform. You know, and you cannot just midway change that platform on the people. So if you want to do that, go back to the relinquish your seat, go back and ask for a new mandate. And if in terms of expulsion, if it is the National Assembly can suspend their members because they have to be governed by certain rules to ensure, you know, proper discipline within the House, but they cannot expel a member from the House. But in any case, whoever loses his or her seat, for one of the reasons that we have provided for in the draft constitution, they are entitled, obviously, to also contest. For example, if I join a political party today and I win, become a National Assembly member, I decide, you know, I don't like this party's policies or ideas, you know, the way they're going. I decide to join another party. I lose my seat because I can't do that, because cross-carpeting is something we are not allowing under the draft constitution, and that's something Gambians have said to us. But under those circumstances, if I lose that seat, I'm still eligible to contest for the seat. The people will decide whether they'll vote me with my new mandate for the specific party that I want to join, or whether I might decide to go independent and campaign on that basis.
I think that's very clear. Chairman, questions have been coming. Another question is the issue of secularism. You have been discussing this since the draft was issued on the 14th November 2019. They are asking, are we going to remain a secular state?
You know, the Gambia, the way it is at the moment, if you look at all the provisions of the 1997 Constitution, it is a secular state. You know, that's just the truth about it. And that was precisely why the Constitutional Review Commission Act in Section 6 made specific provision as one of our guiding principles to ensure that the secular nature of Gambian society continues to be respected in the draft constitution. And you are right, since we published the draft constitution, I believe it was on the 15th of November, there have been a lot of discussion on this. It all started from a particular angle, and I've seen a lot of writing here which is saying that the CRC is making the wrong is giving the wrong response. But there's a history to this. When we published this, the first debate started on the basis that the CRC omitted the word secular from the draft constitution, when in fact it was there. This was the first argument. And we had to rectify that. We had to rectify that to say that the word secular was in fact constitutionally never part of the Constitution. It was not in the 1970 Constitution. It was not in the 1997 Constitution. So that was the background of that. I've seen recent writings where they said, well, those remarks are not helpful, but they haven't contextualized the response. The response was given on the basis of what was being advocated and what was being said, because the CRC was being accused of removing a word that was in the Constitution. So the response was, it was never there, you know. But we encourage people, and we said today, if you want, if this is a word you want to be included in the Constitution, it is a draft. It is still open to debate, and that's precisely why we have rolled it out, because we want people to express opinion on that. So tell us what you want. If you think the word secular should be, give your reasons. And this is exactly what we've been saying even from the first consultation. Just don't tell us to put it there and stop there. Give your reason, because this is a subject matter we had considered at the drafting stage, and it is something we continue to debate. But I do welcome the debate, and I see now it has shifted. There is now recognition, I believe for the first time in our meeting in Kerewan just a few days ago, we heard people from that particular community admit for the first time that yes, the word secular was never in the Constitution, but now they are advocating for it to be included in the Constitution. And we've had something to that effect again in Diaspora yesterday. And that's the sort of dialogue we are looking to. We are not saying that the Constitution is, the draft Constitution is final. It is just a draft ruled out so that our citizens can debate the provisions in it and then look for a way to deal with it. We haven't closed our minds, and I think, Sina, you know exactly how we operate. We have always been very open-minded about ideas from our people and from other stakeholders, and that is a principle and a policy that we continue to observe. All I would encourage and advise is that the dialogue and the debate should be kept healthy. Let's engage without rancor. You know, I think we can do it together. The essence is that those who are saying that the word secular should be, they are speaking from a particular background. And all of us need to recognize that. Yes, there are opposite views as well, and those also have to be considered. But ultimately, it is what really will keep this community of Gambians together, you know, as we have always been in history. That is most paramount. And how we achieve that, again, will largely depend on the contribution, the helpful contribution that we continue to receive from the public.
Thank you very much, Chairman, for that response. Another question here from one Sekou Sedili in London said, why can the CRC consider abolishing the post of VP and creating the post of a political prime minister who will focus on running the government, implementing serious reform, and moving the country towards development? The presidency is too busy with party politics, etc.
You know, this is I believe, if memory serves me well, the first time somebody is making this suggestion, which is why from the inception, we've been saying, look here, we need people to come forward and make their contributions. What people have been saying and what we had discussed in the past related to whether the president should have a running mate in order to ensure that level of continuity in the government in the event something happens. But obviously people have rejected that flatly. A very, very tiny minority advocated for that. And we had to develop, we are developing this constitution largely on the basis of the wishes and aspirations of Gambians, on the basis of treaty obligations as a country, on the basis of international best practices, and above all on the basis of national values and ethos of the Gambia. So these are the four fundamental principles which have really been guiding action as the CRC, and where we have turned around and said, well, this is what is said, but this is what the best practice is. We will provide, and we've been providing our reasons for that. And you know, the draft report that we will be preparing hopefully will be very comprehensive in terms of rationale for quite a number of the areas, particularly those so-called contentious areas, because we do all need to work on this together and hopefully finalize it in a way that best serves the interests of this country through today and future, today and going into the future.
Thank you very much. For those joining us, this is CRC, Diaspora Online Media Engagement, offering them an opportunity to also contribute towards this draft constitution. We are at a final stage of incorporating comments and observations. So, Chairman, another question from Citizen Jallow from the United States. He has been one of our key followers online. His question read, has the new constitution defined the role of regional governors to create demarcation between them and the councils?
The answer is there is no reference in the draft constitution on regarding regional governors. This is a subject that has also been canvassed during our initial public consultations, but it is also one we've consulted on extensively within government in order to understand the history behind this particular office, the rationale for it, and the basis effectively on which they function. The regional governors essentially are civil servants. You know, that's what we have all come too, in terms of our understanding. They are civil servants. They are appointees from the executive to represent the executive in the regions, to inform the regions about the executive decisions, and also to transmit the region's views and whatever ideas they canvass to the executive. So effectively, it's just a representative institution. What we have done to prevent any conflict, because we've been hearing this during the public consultations between the Office of Regional Governor and the local government authorities, we've created a new chapter on local government and decentralization. And we've empowered local governments. We are very clear in terms of the functions, how those are delineated with regard to the Office of Council, the Office of the local government authorities. So those are clearly defined. So hopefully there won't be any conflict going forward, because the powers, functions of local government authorities are outlined. In addition to that, we've empowered the National Assembly to provide further powers and further functions with regard to all local government authorities. So hopefully there won't be any conflict going into the future once this constitution, if and when it is adopted.
Yeah. Thank you, Justice Jallow. Another question from one Pa Sambu Junior. Good, Mr. Jallow. Could you kindly explain to Gambians why the draft is closer to Yahya Jammeh's vision when he declared an Islamic state than the objectives of your mandate under Section 6 of CRC Act?
I believe I've already explained this. Section 6 of the CRC Act really is a guiding principle which tells us to maintain the secular nature of Gambian society, and that is something we believe we have done in the draft constitution. Some have disagreed, and we are still open to ideas in that regard. I think it will be unfair for anybody to say that this constitution is tied to a particular interest group or particular regime. I mean, this is a constitution we have consulted on widely, and it effectively represents the opinions we have been given by Gambians. And you are aware, during this round of public consultations on the draft constitution, we've been telling people, this is what he said to us, this is what we have provided. Tell us whether we've actually captured what you said. And people have been reacting to that, and effectively, in essence, it's been very positive. And people have been telling us, well, you know, this was what we discussed, this is what you provided. You did not provide something, but we see your reasoning for it, and we agree with it. You know, so this is the sort of conversation that has been going on. But I think it will, I mean, and I respect the view, but I certainly do not agree that this particular draft constitution is designed to represent any particular regime or any particular interest. This is very neutral in my view in terms of ensuring good governance going into the future.
Yeah. Thank you, Justice Jallow. Another question here: reasons why changing from the Qadi court system to Sharia High Court?
Yeah, the Qadi hasn't been changed to Sharia High Court. Currently, what we have in the Constitution is we have a provision on creating the Qadi Court. We also have a provision creating the Qadi Appeals Panel, which effectively serves as the appeal body to which appeals from the Qadi Court emanate, or go to. In essence, what we have done is just do a name change. The Qadi Court currently is now being transformed into the Sharia Court, and they deal with issues relating to adoption, marriage, divorce, burial, and devolution of property. Their jurisdiction is very much restricted. If you look over time in our constitutional history, we used to have what we call Mohammedan Law Recognition Act. And as time went by, we recognized that that was the wrong name. It's not Mohammedan law. That's not what it should be. It should be Sharia. And that was changed. The law was amended. It's now called Sharia Recognition Act. So that is there. So this is in the same vein where Qadi is being changed to Sharia. All right, but the jurisdiction remains the same. Instead of the Qadi Appeal Panel, we've established the Sharia High Court, such that those who are subject to it, and it's only Muslims that are governed by that particular legal system. And it's been there in the 1970 Constitution. The Cadi Court has always been there. So it's just to afford people who go through the Cadi Courts maximum opportunity to appeal their matters right up to the highest court. We think it's only appropriate to do that, but it is not designed really to create an institution that has an ulterior motive. You know, it's there to cater for what is currently in the draft constitution.
Thank you very much for answering to these questions. Another one from Sekou Sedili again. How come the constitution doesn't have a mandatory provision for diaspora as the 8th region to have at least 2 elected representatives at the National Assembly?
Well, some have advocated for it, but it wasn't really anywhere close to a majority. We have also considered the logistics of having that kind of representation, along, for example, with the provision whereby, as a member of the legislature, you are supposed to be, your attendance, your regular attendance at sittings is supposed to be ensured. So, in addition to that, also, there are issues as to how diaspora elections will be held, for your 2 candidates, considering the Gambians are all over the world. We recognize that 1 country has done it, or maybe 2. But obviously, it is resource intensive, and there's absolutely no guarantee that the ultimate objective of ensuring that all Gambians, in the diaspora participate in this process can be assured. So what we have done instead is to make provision. If you recall, in the current constitution, if you want to contest a parliamentary seat, you must be ordinarily resident in the country for at least a year. We have removed that provision. So there is now no discrimination really between Gambians overseas and Gambians within the country. So if you want to contest elections and you are in the diaspora, you can come a day before nomination, provided you meet all the other requirements outlined in the draft constitution, and contest. Whether you win or not, that's a different matter. But now we are creating that opportunity for everybody instead of creating a specific constituency in that particular regard. I also, considering the fact that did not carry much traction.
Another question again, Mr. Jallow, are there any circumstances under which non-Muslims will be subjected to Sharia jurisdiction and also Muslim opt out of Sharia?
The rules relating to Sharia as established in the current constitution and as envisaged under the draft constitution is clearly spelled out. It relates to personal law. That means it's only people subject to that to Sharia will be affected. In other words, the Sharia court will not and does not certainly have any jurisdiction over a non-Muslim, somebody who professes a different faith. And I think people need to realize that. And this is nothing new. It's always been there. It's just been replicated. I think what has created some concern is the use of the word Sharia. But the Mohammedan law recognition of I told you was changed to Sharia, but there really wasn't any particular concern. And I can understand that because this is the constitution. So, it certainly carries more weight, and I can understand the concerns. But I just want to assure everybody that there is no ulterior motive to this process. We have our integrity to keep. We are professionals, and we also have to recognize what the tradition has always been. I mean, we, in our view, in our considered view, do not think it will be appropriate to remove what has always been there in terms of providing for personal law, whereby for a limited area of jurisdiction, persons belonging to that faith are governed. But this certainly will not in any way apply to non-Muslims.
Thank you very much. You are watching live from Basse, the CRC Diaspora online engagement with the chairperson of the Constitutional Review Commission, Justice Cherno Jallow. Send in your comments, your questions. The chairman will endeavor to answer them before we close this conversation. Chairman, another question again on secularism. What will be the final decision of the CRC after this final phase of public consultations?
Well, I cannot anticipate that. I think that's precisely why we are consulting. We are inviting people to canvass opinions with us, and then on the basis of what they say to us, we will sit as we did with the first phase. We will sit down, we'll look at the subject matter again, we will carry out further research where we need to, and then come to a determined position in terms of what should happen. At this stage of the consultation on the draft constitution, I cannot, and certainly it will not be appropriate. In fact, it is impossible for me to tell anybody what the final decision is going to be. We work as a team. There are 11 commissioners, so it's not the opinion of one that carries the rate. Just because I'm chairman doesn't mean that I can determine what goes into the constitution and what doesn't. We do that as a collective body.
Another question here. Explain further why should a minister appoint a alcalo while chiefs are voted by the people?
Well, when we consulted on this, the overwhelming view was that chiefs should be elected by the members of their districts, but that of alcalos should remain traditional, should be done by way of tradition. Now, what that means effectively, there is no specific provision in the draft constitution that the minister appoints the alcalo. I think what we have provided for is that the appointment of alcalos should follow traditional lines, which means that if you belong to the lineage of the alcaloship and an existing alcalo no longer occupies that seat, somebody within that lineage takes over. That's the process we have provided, and that's designed to ensure that we maintain our traditions. It is on the basis of maintaining the same tradition and giving it the weight it deserves. Why the draft says if you serve as an alcalo and or as a CFO, then you serve for a lifetime. There are conditions, of course. If you die naturally, if you resign, then obviously that terminates the appointment. Or if you are removed from office for misconduct, misbehavior, or on account of ill health that you can't perform. And there are processes in place, but these are all designed to ensure that the institution, these are very traditional institutions, and these are traditional institutions which we felt very strongly also, and the people have said this to us, that we need to bring back the glory days of the CFOs, of the alcalos, where the institutions are respected, because they are seen as the nucleus of community unity, and which is again why we went further to make specific provision that if you are an alcalo or a CFO, you cannot engage in partisan politics, because that basically dilutes the essence, whereby the essence of communal engagement with the leader of that particular district or the village. So that's what we want to avoid, and people have said that to us very clearly. They don't want their chiefs, they don't want their alcalos engage in partisan politics, because ultimately when they have disputes, when they have issues, they go to these people. And if they are party politic people, they will lose confidence in terms of their engagement with those institutions.
Thank you very much, Chairman. Someone is saying, thank you, Chairman, for your befitting responses to our questions. We thank you. Another question from One Day Fatu Sogna. How did the CRC come to the conclusion the diaspora vote is resource intensive? Is that not the job of the IEC?
Well, you can say that, but one of the things we have been doing as the CRC people have said so many things to us that they want, but we have to look at the cost factor as well. It is one thing to say, for example, if you know, it's the electoral body that has responsibility for financing issues, but we cannot put something in the draft constitution, and we've had discussions with the IEC as well and all the other relevant institutions. We cannot put something in the constitution that's going to be so resource intensive to the extent that it becomes impossible to administer. So effectively, you'll be creating a very rigid constitution. We didn't want to do that, and that's not realistic. What we thought we needed to do was to craft a constitution that was fitting enough to meet the requirements and aspirations of the people, but also not being rigid. Because if you create that, that can be a potential problem. And we've had to consult with officials dealing with public finances, Ministry of Finance, and other key finance institutions, the central bank. You know, we've consulted. You know, it's not only what people have been telling us. We have also created technical committees because we realize that we are not the experts in everything. We created technical committees on public finance management. We created technical committees on land, environment, and natural resources, on media, public education, and so on. And this was designed specifically to bring in the experts to tell us. And what we did was to lay to them specific aspects and say, this is what the public said. We want you to look at it from a finance standpoint, you know, from environmental standpoint, from a natural resource standpoint, and give us your expert advice on this. And on the basis of that also, we carried out our own independent research. So we did employ a lot of mechanisms. So it's not just that because a particular body has responsibility for administering something, so we shouldn't worry about ourselves about the cost. No, that's not the way it works.
Yeah. Thank you, Chairman. Another question from Yang Sisao. Mr. Jallow, what is the specific job experience for grade 12 certificate holders to run for office of president without university degree, public service, or even being in a private business?
One of the criteria we have outlined in the draft constitution is that if you want to run for president, you have to have either a university degree plus 5 years experience, or a high school, that is a senior secondary school living certificate with 12 years experience. It doesn't matter where that experience is gained. So long as you can establish and you can satisfy the electoral body that you have been engaged in some activity that has developed your experience post academic qualification, that should suffice, whether it's in the public service or in the private sector. Even if you are self-employed, that all counts. The whole essence of this is effectively to make sure that people don't go into office as novices. You know, in the context that you've never had work experience and you're going into a new position as important as the office of president. You need to have some experience. And the public has been telling you, say, look here, we don't mind the academic qualification, we don't mind what qualification you have, but you cannot buy experience. And we want people who are experienced so they can properly represent us and not only be mindful of what they say, but also to equip themselves better in terms of knowing how to address concerns that the people have. So that's the rationale for that.
Thank you, Chairman. More questions are coming. Very interesting conversation. For those tuning in or viewing, this is Constitutional Review Commission, Diaspora online engagement, an opportunity for the diaspora to also participate in the draft constitution. We are live from Basse, Upper River region. We'll be taking more questions as we move into the program. Another question coming from Khalilu Jaite. Left to the IEC and the government, diaspora will not vote because they will claim of limited resources.
Well, I understand the view and where it's coming from, because this provision that arrangements should be made for diaspora to vote has been there. It hasn't materialized over time. So one can understand opinion being expressed in that particular context. But I think what I can say is that we have been engaging with the IEC, and it's one of the bodies that has really been very effective in terms of how they've been engaging with the CRC. And I hope I'm not divulging, views relating to. But in their defense, I know arrangements are in trend to see how best they can assist with ensuring that the diaspora participate in dealing with elections. There will of course be cost issues and so on and so forth, but I'm sure and I hope that is something that is being looked into. But what I can say to the person who has asked the question is that we have to have faith. I think we all always say we are in a new dispensation and we are trying to move forward, and some element of faith has to exist in order to ensure that those who have responsibility for carrying out certain duties actually recognize that the people have that concern, and they need to double up their efforts to ensure that what is provided for in this constitution, whereby diasporans can actually vote and fully participate and exercise their franchise, is achieved. So I won't be so much of a pessimist. I would rather be an optimist, recognizing the level of engagement of the IEC on this particular subject.
Yeah. Another question from Lizzie. Can you please help me understand how a non-Muslim woman from a mixed marriage can get a fair inheritance under a Sharia law?
Well, I wouldn't claim to be an expert in Sharia. I think that's more an issue of litigation. And but I think what the limited knowledge in Sharia that I have, even though I've studied aspects of it, is that the Sharia has outlined certain principles, certain guidelines in terms of who inherits and how much you can inherit. There are all those provisions that are recognized. A non-Christian woman, for instance, under Sharia, a Muslim man can have that kind of relationship. A Muslim man can. I wouldn't see in a situation where a non-Muslim woman, having lived through the marriage and it comes to inheritance, that person is deprived. But quite clear, like I said, I don't want to be the one to specifically pronounce on such a matter, because these are issues generally of where disputes are involved. There are issues of litigation involved, and there are a lot of issues. But the fact of the matter is, the rules of Sharia, in my view, are clear on those things, I would think, and there are matters to be resolved within that particular context. I wouldn't deal with any particular
And
case.
this is captured in the draft constitution.
The draft constitution makes provision that applies the certain rules, the rules of Sharia in specific respect, as I mentioned earlier. That's in marriage, divorce, inheritance, things like that. The specific question relates to whether a non-Muslim woman, that's my understanding, I may have got it wrong, involved in a marriage with a Muslim person, whether that person can actually inherit. I think that is the question.
Yeah, this one is a football or a sport lover. He's asking, why is the provision on sport in the 1997 Constitution left out in this draft?
I would like to be guided on which provision deals with sports. I know there is this specific chapter on National Youth Scheme, and having consulted extensively on it, and we did specifically consult with the National Youth Service Scheme on this. What they've indicated is that provision of the Constitution, that chapter of the Constitution, has really never worked. It's really never worked the way it was intended. And again, it was a resource issues from what we have been told. So we thought that rather than replicate what hasn't worked, we would rather put in a provision on how youth can be developed, and put obligations on the state. For example, to ensure that when the state is developing policies policies, whether it's in the area of youth development, whether it's in the area of sports, or whether it's in some other area. Specific provision is there that the youth have to be consulted. You cannot develop and conclude on those policies without consulting with the youth. But obviously, I stand corrected where he said there is provision currently in the Constitution on sports. I don't recall seeing a specific provision to that effect, but I'd be happy to be guided.
Yeah, that's Pascal. If we are watching, Chairman want to be guided on a provision in the 1997 Constitution in relation to sports. As you said, this is a draft, and your comments and suggestions are welcome. Chairman,
and perhaps, if I may just add there, if I'm sure this is a sports enthusiast, and if he feels that a provision should be included in the draft constitution in relation to sports, I think it would be very helpful to us if he were to share those views with us, and also to give us his reasons why he thinks that those should be captured in the constitution.
Yeah, certainly he will share those views with the CRC. Those views can be shared with us on our official Facebook page, the Constitutional Review Commission, the Gambia, and also via our email address, crc220.org or info@crc. You can send your comments, your views on the draft constitution that is been currently been discussed throughout the breadth and length of this country. Justice Jallow, I think we will soon be rounding up. We are left with 30 more minutes, and questions are still coming. Another question is resource issue is coded language. We know what it means. The government and the elites are terrified for an inclusive democracy. No one can buy or control the diaspora. That's a question for one of our diaspora followers. She has been constantly on us on Facebook. So this is an opportunity for the chairman to also answer her question. She is Ndefatu Sogna.
Well, I don't know what to tell Ndefatu. I mean, safe to make the point that Ndefatu, we are in a new dispensation, as we call it, and we are trying to reform. We are trying to move forward, and in that process, I think we all need to be optimistic. I think that is important. There are certain values that have been developed and included in the draft constitution. What we as citizens to do is to make sure that we look at this constitution properly, inside out, unravel every aspect of it, and if eventually it becomes the new constitution, we guard and protect the constitution. We hold people accountable in terms of the values, in terms of the requirements that are enshrined in the constitution. For me, that is the only mechanism that one can employ effectively to hold people accountable, because these provisions are there. They are not there for being, for just being there. They are there for a purpose, and if those purposes are not being made in the sense that office holders are flouting it on the basis of excuses, we as citizens have been given responsibility. We have even been under the draft constitution to bring action. Even there's provision now on public action litigation. It was never there. So if you feel that there is specific lagging behind in terms of complying with the provisions of the constitution, anybody is free to bring in action to ensure that the purposes, the objective of the constitution and the legal requirement or the constitutional requirements are being fully accorded the merit that they were intended to have.
Chairman, another question still on this issue of the Sharia High Court. I think there are some questions that are kind of repetitive, so we will not be able to, when we answer a question that is similar, we will not be able to take up that question again. But it seems a different questions. How can you please clarify the supervisory jurisdiction of the High Court on the Sharia courts?
What we have done is the High Court is a civil court, effectively. The Sharia High Court is a Sharia court, and the High Court has supervisory jurisdiction over subordinate courts that implement or apply civil-related matters. For example, the magistrates' courts. The High Court will have supervisory jurisdiction over that court. Now, in terms of the supervisory jurisdiction of the Sharia court, is the Sharia High Court that will have that responsibility. So we have delineated that responsibility as clearly as we can, and I think that is the right way to do it.
Thank you very much again for those of you viewing. This is the Constitutional Review Commission Diaspora online engagement with the Gambians in the diaspora, and also those who are not lucky enough to attend our final phase of public consultation. With me here is the chairman of CRC, Justice Cherno Sulayman Jallow, who is doing everything possible to answer your questions. We will look another questions on the feed. There is one here. Is another question from this one is more of an observation from one Lamin Barrow. Unemployment is very high in the Gambia, so why you bar citizens from graduating after graduating from university or high school to stand for presidential election on the ground that they have 5 or 12 years work experience?
Well, I think I've addressed that, and I have indicated very clearly what the public has been saying to us. Experience is important. To run an office as important, and relevant as the office of president. The public has been very loud and clear on that. They don't want a novice in that office. I do take the point that unemployment is an issue in the country, but certainly that is not designed really to keep anybody out of the presidency. In other words, keeping the person away from being able to contest the election. Just because you have come straight from school, you can't find a job, doesn't mean that you should be able to go and contest the presidency. Not that you cannot, but all that the public is saying to us, get some experience, and then you can run for office.
Thank you, Chairman. Another question is, I want you to explain. We have had a lot of opinions from Gambians with regard to what they want to see in the new constitution. And not all these issues are constitutional issues. How do they find themselves in the new draft constitution?
What becomes constitutional depends on what the country provides or considers to be a priority. I think after we started initial public consultations, I did make the point that this draft constitution that we are going to develop may not be the typical kind of constitution that we are accustomed to seeing, because this would be people-centered, because it makes absolutely no sense, in my view. Just replicating trying to replicate that you see in other countries. Otherwise we wouldn't be consulting. We consulted on the basis that people have views, and we needed to listen to those, build them into constitution. It is not. It won't be accurate to say that we have included relevant, but also to pin the wishes and aspirations of the people, in order to ensure that we have a constitution that is that is reflective of the public's view, a constitution that ultimately people can take and say, this concerns, this addresses issues that we canvass with the CRC. We have tried to manage expectations, and we made it very clear to the public. It is not everything they tell us that we to the Constitution. And they understand that. I think people just wanted to make sure that they were listened to. But when we sat as the CRC, we considered all of these issues and looked at the totality of the evidence we've collected in order to be able to determine what really needs to be captured in the draft Constitution.
Thank you very much, Chairman. Another question is, how can we recall parliamentarians that are not serving the interests of the masses?
Well, the draft constitution makes very specific provision on this. It outlines the procedure. What it provides is that where, a parliamentarian qualifies to be recalled, at least 1/3 of the voting population in his or her constituency, once they petition the speaker will then look at the matter and send it to the electoral body, which will then determine whether the procedures and the requirements outlined in the Constitution are fully met. And if that is done, then it goes back to the speaker, who will then authorize the recall. But again, we are still open to this, because I know there are some people who have expressed opinions on this. For example, one opinion we've received is why, for example, one said the threshold, the 1/3 threshold is too low, all right, for a recall. There is also another opinion that is the House that should determine and debate the matter and determine whether one should be recalled or not. So there are different opinions being canvassed in this particular area, and we will just welcome further opinion on this to see how best we can ensure and hold our parliamentarians to account.
And just to let the viewers know, this is just the draft constitution, so your comments are valid. You can send them, as I said earlier on, through our official email, info@crc220.org, or also crcgambia@gmail.com, or better still, visit us at Featurelek Building along the Battling Harding Highway in Kotu. The deadline for submission of the deadline for submission of comments, suggestions, and observations is 15 December. Another question from Coach Pasamba Jao in the United States. He said, if the CRC finds it necessary to make Sharia permanent in the Constitution, why is it shying away from inserting the word secular?
Thank you, Pasamba. I think it's a question of the CRC wanting to make Sharia prominent. Like I said, we've had, if I look at our and during our public consultation, certainly there was no opinion that we should dispense with it. Absolutely none whatsoever. So we have provided for it in the draft constitution in the same vein where we thought that the previous constitution never had the word secular, and we've always lived as a community together in harmony. That position should also be preserved. But quite clearly, like I said, if people still think that the positions should be reversed in one form or the other, we welcome them to share those opinions with us.
Yeah.
I think people shouldn't treat this as if everything is cast in stone. And I think also when we make these observations, we need not look at what is there today. We need to tie it to the history in terms of what was there and whether it has worked and worked well. And what would be the situation or circumstance now that would necessitate dispensing with that regime and coming up with something new. These are all elements that I think people need to look at so that we have a holistic picture in terms of our approach.
Thank you very much, Chairman, for answering to that question. I think you have answered this, but let me just read it. Maybe the person is just joining the conversation now. It's one Keba Bojang. Is there any section that protect the poor communities from land grabbing, especially from physical planning officials? you made mention about a new provision on environment and land. So you might want to explain further.
Yes, we have, and frankly speaking, this very question that he's asked is what people in this country have lamented very seriously to us, that people within their communities are being robbed of their land to the extent that a large chunk of community land has now been lost, and even their animals can't have anywhere to graze again. And in the North Bank, for instance, people have complained to us, the same as in the West Coast region, whereby the cattle herders themselves, because the traditional lands they used to graze their animals on have now been taken away. So they just let their animals loose, and what they do, they go and destroy people's gardens, you know, and things like that. So it's really, it's a real issue. I understand his concern. His concern is shared by a majority of Gambians who have expressed opinion on this. So what we have done in the draft constitution is to make sure that if you look at it right now, a lot of the concerns relating to, at least of the way the people have narrated it to us, and upon inquiry we found that this to be so, we have a real estate industry that seems to be totally unregulated. And that is creating a phenomenal problem in this country. We've discussed that with the Ministry of Lands, and they acknowledge the problem, and I believe they have comments doing something about it. But the fact of the matter is, Gambians owning land in their country is not something we can restrict, and it's not something we envisage we can ever do properly. So it is not there in the Constitution. What we are saying is, if you are going to deal in land in relation to a non-Gambian, there are restrictions that apply. And those restrictions need to be followed right through in order to ensure that ultimately Gambians at every stage that we are in is not deprived. The Gambian is not deprived of his or her land. I think that is a crucial position we have taken. But again, I've heard that there are people who are against that, but I haven't read any opinion on it as yet. But I look forward to control reviews that we have provided for in the Constitution.
Thank you. More questions are coming, and time is not on our side because we will be engaging more Gambians on this draft constitution, both off and online. Another question from Kalilu Jaite, Mr. Chairman. He said Section 92(1)(e) should be clearly defined, with it means convicted by a court of law, because there are many Gambians convicted by courts illegally, like that of Mr. Dabo and co.
What we have provided specific offices, and that of President is one of them, is that again, based on what the public has said to us, they want people of integrity in the office of President. They want people who do not carry that baggage of criminal conviction, and that is what we have tried to build into the draft constitution. But we've also made a specific provision that conviction debars you from being able to contest the presidency only if you have not been pardoned for it. If you are pardoned, it wipes off effectively your conviction. You can still contest the presidency. And I don't want to comment on any particular case here, but the provision is there. And also based on what the public has been telling us, we've made provision that if you are convicted of a particular offense, depending on the gravity of the offense and the sentences carries, that is what determines whether you will be eligible to run for president or not. It's not the penalty that is handed down on you.
I think that's very clear, Mr. Chairman. Another question from Ibrahima A. Toure. Can you please elaborate on the tenure of the chieftaincy it seems chiefs have a lifetime employment.
Well, I guess that's another way. That's another way to put it. But like I said, the reason for that, we wanted to make sure, and Gambians have said this to us, we want to bring back, the traditional value of chieftaincy. That has been seen to be political, and people have said want to move away from that. We revere want to continue the tradition. We don't want our chiefs, involved in politics. We want a situation where we all see the chiefs as the rallying points, where when we have issues, we can go to the chiefs and they can settle it in a very communal way. And that is what people miss, and they wanted to ensure that. So yes, you can say that they've been given, in the draft, at least for now, a lifetime employment. But frankly speaking, chiefs don't get anything. In terms of remuneration, really, they don't get much. And this is one of the things they've canvassed. Obviously, we cannot put that in the draft constitution, and we've made that clear to them. But effectively, what this ensures, and where the emphasis is to restore the glory of chieftaincy in this country.
Thank you very much, Chairman. Will this term be part of the 2-term of the office of the President? I think you have been answering this question, but it's another opportunity for them so that they will be able to know the 2-term limit in the draft constitution.
Yes, we have looked at this very, very carefully before we came to a position on it to include in the draft constitution. We have seen in quite a number of countries, particularly on the African continent, where the subject of the incumbent's term is not addressed. It's left to interpretation, judicial interpretation. We decided that that's not the way to go, because it's almost always ended up in conflict, and in some instances the judiciary arms being twisted to go one way or the other. We thought that the best thing to do is to clarify the position based on the discussions again we've had with our compatriots during the public engagement, and we've done our own research, like I said, into this, and also sought the advice of our 2 external consultants on the subject. We thought we would make it very clear in the draft constitution that the incumbent president term will count towards determining the maximum time he can serve. In other words, the maximum time is 10 years of two 5-year terms each, which means the current president serves his term. He can contest and serve for another term, and that will be the maximum. I think that is very clear. Whether one agrees with it or not is a different matter. But the fact is that on the Schedule 3 of the draft constitution is made very clear that the current term counts as part of the 10-year period.
Someone is asking, is this presidential term an entrenched clause?
It is entrenched. It is entrenched in the sense that you cannot amend that provision without going through a very rigorous process. But also we have put in a specific provision prohibiting the National Assembly from passing legislation to extend the term of any president. We think that is important, and it is consistent with the term limit that we have set in the Constitution.
Chairman, I know it's Friday, and then time is not on our side. We are just left with 5 minutes to round up this conversation, but more questions are coming, so we'll advise them to send these questions, comments and suggestions to our Facebook page, our Twitter, and also you can visit us at Kotu Feature-Lake building along the Battling Harding Highway. For those tuning in or viewing anywhere you are, we are live from Basse in the Upper River region on the Constitutional Review Commission final phase of public consultation with Gambians on the draft constitution. So, Chairman, I will finally give you an opportunity to address Gambians, your closing statement before we round up this very important face-to-face engagement with Gambians in the diaspora.
Thank you very much, Sini. I mean, I must express delight at the active engagement that compatriots in the diaspora have really taken in terms of seeking clarifications and expressing opinions. I thank them for that. They should consider this as just one platform. The dialogue need not end here. I think people need to still continue to engage the CRC through the various platforms that we have established, and we just announced them here a while ago, so that we have a better understanding of their opinions. I might have said something here that somebody may not agree with, or somebody may feel hasn't been satisfactorily explained. We invite them to write to us on those matters, and we will, just like with the first constitution, we will look at every single matter that is submitted to us. That we do not consider anything as irrelevant. We consider everything, because at the end of the day, we want to be accountable and to be held accountable in terms of the views that Gambians have expressed. The final thing I want to mention here is that we've seen a level of engagement in this constitutional review process that I never ever thought we could have achieved. I mean, as we consult at the moment, through with the various communities. I mean, we've seen communities turn up in their large numbers, and we've seen them sit down throughout the day, listening, contributing, and also asking as many questions as possible in terms of how they wish to be governed under the new constitution. That is an engagement we need to continue to do. But we do not want this constitution, and I need to emphasize this, to be a divisive instrument. We are all in this together as a people, as a country. We all have a responsibility through this engagement process to ensure that we, the CRC members, are properly informed by the public, because that is what will help us to craft the final draft. We did say from the very beginning that we will come back to the people, to let them know what the draft is, how we've dealt with their issues, and so on. That is what we have done, because we do not want this to be a secretive process, because that's not what really takes a country forward. We claimed to have an all-inclusive process, participatory democracy, and I believe that's something we have achieved. We may have had shortfalls here and there, but I think on the whole we have continued to do the best we can to involve Gambians of all shades in this process. So I crave the indulgence of Gambians for any shortcomings that we may have, but again, that's why we've ruled out the draft constitution so that people can add views on that and let us know what is good and what is bad, so that we will be in a position to look at the totality of everything we receive to craft the final draft of the constitution. And perhaps I should add this to make the point that once we receive all opinions on this, we will move forward to finalize the draft constitution. Now, under the law as it stands and as we are governed by, once we finish that process, we have to hand the draft constitution formally to His Excellency the President of the Republic, along with a report. And the report will explain a lot of things in terms of what is in the constitution, what has been canvassed and included, or not included. All of these things will be will be provided in the report. But also it will provide for things that we think are relevant to ensure appropriate governance, but couldn't make it into the constitution, because it's not everything that goes into the constitution, but they are important. We think the government and all those concerned should be aware of. So the report will aim to capture all of those things. When we hand the report to the president, at the same time, the law gives us the power to publish it. So whatever is handed to His Excellency the President, the public will see the same copy. People have been asking us, some people have been saying, in fact, every meeting so far we've been to, people have been telling us, we don't want this constitution changed. once you finalize it, we want it to go on. But again, that's out of our hands. We have a mandate. Once we fulfill that mandate, it's really for the people now to follow up that process. And people will know what changes have been made and what was there originally. But the idea, and I know this, I've had this conversation even within government, the idea is to do the best we all can, both government and those of us citizens, not in government, want to ensure that we have an instrument that not only is people-centered, but that is of a nature whereby there won't be any need for further changes to bring in one view or the other. Because people might see that as representing personal interests and things like that. That's something we hope will not happen. And I say these things because people have been telling me this, as we go around the country. So I think on that basis, we continue to be open-minded about this process. We continue to encourage our citizens to communicate or continue communicating with us and to do the best they can. Let them find the time. This is very important. It's a historic moment. It's a one-lifetime opportunity for every one of us, and to contribute as meaningfully and in a very constructive way. And when I say constructive way, what I mean effectively, don't just criticize. It's fine to criticize, and we know that people will criticize, but give us solutions. Help us. We don't know everything. Help us, and then we will research the subject matters and to total all of that against what others have said to us in order to come to a final determination. And Seni, thank you very much for arranging this and for moderating it so well. Thank you very much.
Thank you very much, Justice Cherno Sulayman Jallow, for that brilliant explanation on some of the issues that are highlighted in the draft constitution. As my boss said, let's keep the conversation going. We'll be having a series of public engagements. Our next meeting will be in tomorrow. We'll be having a meeting here in Basse, the administrative capital of Upper River Region. So we call on people around here to attend our meeting tomorrow. From there, we'll have another meeting in Georgetown, Janjambure, on Sunday. And on Monday, we'll move to Jareng, CRR South. So we'll call on people to capitalize on this last opportunity. I called it a golden opportunity because this is a time you can bring in your observations, comments, so that they can be incorporated in the new draft constitution. So on that note, I also use this opportunity to thank the chairman, who has been very media friendly. Anytime you knock on him, he will be available to answer to some of these questions. So at CRC, that is something that we believe in: transparency, accountability. And I'm happy people are also taking ownership of this entire review process. Until then, bye-bye, and do enjoy the weekend. Thank you.